Welcome to the Legal Real Estate Financial Session. As everybody knows, this goes without saying that 2021 has presented us with a lot of new opportunities that really haven't been presented in the past or you've had to deal with in the past. So we have a really, really good set of panelists that are going to be discussing everything from lease negotiations to bankruptcy terms and some of the other issues that are facing you as both an exhibitor or a vendor, that's really brought these topics to the forefront of our media attention that we really need to address. We want to first of all thank our sponsors for this session, Martin, Frost, and Hill Liquor Attorneys, who happens to be one of the panelists, Encore Performance Seating, and Vista. So we want to jump in. I'm going to quickly introduce our panelists today. Moderating the session is going to be Matthew Baizer, the COO of Flix Brewhouse.
The Dodger
fan. He's in his system.
Am I allowed to speak on that? Because I wore this for a reason.
I know.
Okay, yeah. So you can do that as part of your intro.
Okay, because I want moderator to know that it's for him. Go ahead.
So continuing on, we have Jonathan Friedland. He's attorney with, and I'm going to probably get this wrong, Sugar, Felsenthal, Grais, and Helsinger, and he can correct me. LLC, they specialize in business restructuring.
God bless you.
God bless me. Yeah. Mark Hartman, he is an attorney with Davis Hartman Wright, PLLC, and he happens to be in a unique position where he's not just an attorney, but he's also an exhibitor and part cinema owner. We have Kyle Hill, one of the sponsors of this session. He's an attorney with Martin, Frost, and Hill. They specialize in liquor laws. And last, but certainly not least, is our friend Rodney Speaks, a former owner of Moviehouse and Eatery, which is now Sinopolis. So Matthew, I'm going to kick it over to you since we are being billed by the hour, since they're all attorneys. I'll let you.
It's costing us a fortune.
Don't go away just yet, though, you two.
Okay. Yeah, because
all right, see you later.
First of all, I wore this for you because I want you to know that the Packers suck and pitchers and catchers are reporting in a couple of weeks.
All right, that's it. I'm putting my hat on for the rest of the day.
That was the first thing I needed to say. The second thing is that we need an award for the greatest moment of the Dine-In Cinema Summit. And right now I've got 2 nominations that have to be mentioned. One is Dusty pretending that he's running on the treadmill in that video. Was just an absolute classic. But I have never laughed so hard than when Fred's patent numbers came up.
Like Star Wars. Yeah. Oh,
yeah. So I just needed to point that out, that the all-star moment needs to be recognized.
We laughed hard. Here as well. It was. If we could have had a laugh track on, like if they would have had the microphones on, I don't think we would have heard the music. Everybody would have been laughing across the whole. Anybody that knows Fred would have been laughing.
Absolutely. And speaking of which, John didn't introduce one panelist that I added to the group. So let me show you. He's right here. Hold on. I can go like that. See him back there?
Doing?
You don't see the last panelist over there?
Oh, where is he? No.
You got to make me the big guy.
Oh yeah, focus on Matthew.
Who is it? Oh, it's Bernie. It's Bernie.
Yeah, there you go.
I see him. Atta boy, Baizer. This is why we brought you into this circus, man, because you know how to crank it up a notch.
There you go. So whenever we want to talk to Bernie, I'll just move my fat head. All right.
Now we're getting punchy in the afternoon, so stay with us, attendees.
All right, take it away, Matthew.
I'm going to count on you two to handle questions here because I suspect there will be quite a few.
Okay.
All right. So let's get started. First of all, just get the housekeeping out of the way. John, Amy, Matt, thank you for putting this together, and thank you for inviting me to host this. And I think that we've done a great job assembling these guys for this panel, which should be pretty interesting. Before I get to the specific meat of the presentation and the questions, I think it probably calls for a little bit of honesty here. And that is that I don't know of any exhibitor out there that isn't in trouble. And I'm sure some of the vendors out there are mirroring our situation, right? Because if we can't pay you, then that that equates to vendor problems as well. And it's through none of our own doing that this came up, but it's the situation that we're in. And in the spirit of teamwork, partnership, those kind of things, we're going to talk about some of the ways to kind of work through and work out of the situation that we find ourselves in. At Flix, we made the decision to shut the doors on all of our cinemas back in November. This was after closing in March like everybody, reopening one time, closing again, reopening another time, and then we shut them all down in November. And I don't regret that decision whatsoever, in that we see the anemic grosses and they don't look to be getting any better week after week. And I think that there will come a point in time when it is better. And that then leads to kind of the discussion that we're going to have here, which is what to do about solving issues with creditors and with landlords and those kind of folks as we prepare to get back open. So you got the introduction of the panel, and I'm going to go ahead and ask these guys some questions, and then hopefully the audience will feed me some as well. The format here is I'm going to ask each one of them one, and then we'll give, when that person concludes their answer, the other panelists can chime in with things that they'd like to add, and then we'll just continue to do that rotation, throwing in audience questions as we go. So let's start with Jonathan Friedland, who, as you all heard, is a restructuring attorney. I don't think we need to explain that any further than that particular title, so to speak. So Jonathan, can you hear me okay?
Yes.
All right, great. So let's start with you with this question, because I think that many of the people out in this audience understand the concept of bankruptcy and what it does, and they also understand that there are generally two types. There's a lot of other types as well, but generally two types. You're either restructuring or you're liquidating. So there are some broader banner options that come under the concept of restructuring. And as I said, you're a restructuring attorney. So perhaps you can cover with us some of the less obvious options to some of the people that are in the audience. Because I think with the assumption and the mindset that everybody wants to be able to survive this and have a thriving business, whether they're an operator or a vendor coming out of this. So what does restructuring mean short of the liquidation option?
Sure. So yeah, bankruptcy, it's an umbrella term for several types of bankruptcy that exist under federal law. 7 and 11 are the ones that sort of are most famous or infamous, as the case may be. And then there's new subchapter 5 of chapter 11, which is incredibly interesting, not like academically interesting, but as in interesting for a lot of struggling operators. These bankruptcies, though, are just themselves one subset of a broader set of tools, right, that exist to address the inability to pay debts as they come due, or whose balance sheet is otherwise in the red, right? By way of like nomenclature, an assignment for the benefit of creditors is a state law remedy that looks and feels a lot like a Chapter 7 bankruptcy, but it's usually better, at least from the perspective of the company and its owners. Usually from the perspective of everybody. A friendly Article 9 sale doesn't sound like it's a debtor remedy, a debtor tool, but it can be. That's presuming you know what Article 9 is, which is typically, it's basically a foreclosure procedure. And the most common way to restructure doesn't have, a fancy name. It's just out of court. Out of court workouts are far more prevalent than all the other options combined. Maybe you don't hear about them because they're out of court. And if you're dealing with a company that's not a publicly listed company, then the out of court workout is not going to be public, which generally is one of the benefits of an out of court workout.
Got it. So one of you, just a follow up to that. if somebody is not operating, but generally had a viable business heading into this disaster, but has just burned through every single one of their resources that they have, what direction would you advise, generally speaking, if it was a thriving business to begin with?
Well, strictly speaking, you're not giving me enough data to answer the question, but
Sure.
I'll play along.
Okay.
So
I get that these are all unique, by the way, as I ask that question. I'm just trying to give the audience a little bit more context as to what direction should I be heading if they're scratching their head.
So if the company was doing all right or better before, this national, international, whatever you want to call COVID is, right? Until this stuff hit, then unless we all believe that, Netflix is taking over the world, things will come back. It may take a while, but things will come back. Maybe it'll never come back to quite the level it was at before, but it will largely come back. And the question, so there's no doubt. I mean, we all have to, particularly you guys. I got clients other than theater operators, but certainly you all have to live your life as if the industry's not going away. But the question is going to be who gets to own the players when the rain stops. My point is that, and it's difficult to keep this in four corners, but to be, keep it brief, I have to. I'll tell you what, Google, if you're not familiar with it, Google the term fulcrum security. And when you think about a company that is about to be liquidated and the proceeds of the liquidation are not enough to pay all of the liabilities, they get distributed according to a priority scheme. And senior, secured creditors get to take their collateral or the value from their collateral first. Then come unsecured creditors, and then comes equity. And I think I've seen once in my 30-year career that a time where equity actually got a distribution as a result of a total liquidation through bankruptcy or not through bankruptcy, right? So if what we're dealing with is a temporary issue with valuation, the last thing you want to do is give up. You want to try to find a way to preserve that equity value for yourself. And Chapter 11 is one way to do it. There are other ways to do it, but in a word, a company that's struggling has a lot of alternatives, a lot of options, a lot of now if it has no cash in the bank, that's a problem because you have to pay for the soldiers in the form of the lawyers to fight for you. But if you have a war chest, there's often, but not always, a way to preserve, what's rightfully yours.
Okay. I appreciate that. Thank you. I think you did a good job with my very vague question, kind of framing it a little better for people. I'm going to come back to you because I have some clarifications that I want to discuss that you mentioned initially as well. But let's move off you and give you a little break, and we'll move on to Mark Hartman. Mark, you hear me okay?
Yeah. Can you hear me?
I can. Very well. Thank you. You have a very unique situation that John alluded to when he did your introduction. You are an attorney as well, but you're also a cinema owner. And well, first, before we do anything, why don't you tell us how that came to pass so everybody gets the context and frame. And then I have a few questions for you as an owner and an attorney.
Sure. So I'm a business attorney. I do a lot of commercial real estate work, primarily in the banking and finance industry, but I also represent buyers, sellers, business owners, landlords, borrowers, anybody, investors, anybody doing commercial real estate business, but primarily I represent banks in those transactions. 15 years ago, a client of mine asked me to invest with him in a shopping center, which I did. And that shopping center had a theater tenant in it. Ultimately, that tenant left, and we were faced with the decision of whether to hire a management company to come in and run the theater, or to lease it to a company that runs theaters, or to try to do it ourselves. And we did a lot of research, and we ended up opening it ourselves. And we've been operating that since 2011. And that's a 6-screen cinema in our town in North Carolina. And since then, I guess in 2018, another opportunity came up and we acquired another theater nearby, and that's a 3-screen cinema. And since we've done complete renovations with recliners and draft beer and wine and all that. So we're very into the industry. We're very invested in it. We like it a lot, but yeah, it does provide, I guess I've gotten involved a lot in a lot of the legal aspects of it as well, since I do our legal work for us. So that's sort of my background.
Yeah, so that poses an interesting question. I'm going to get back to you later on with a question about management contracts also. So, but for now, tell us about what you did as the pandemic hit, because you're the landlord as well as the tenant, correct?
Correct.
So you didn't have any restructuring to do related to a lease per se.
Correct, but I think all the leases, all the landlord and tenant issues ultimately go back to whatever the landlord's lender is allowing them to do. Because if the landlord has to make its payment every month, then that landlord's going to be counting on the tenant to make the rent payment also. So it all sort of flows up to whatever the landlord's able to do anyway. So our lender gave us 3 months of no payments on our loan on our buildings. And in return, we were able to allow our operating company not to have to pay us a rent on those locations for 3 months. Some lenders, I think, have done 6 months. Some did like interest only. And again, whatever the lenders were doing for the landlords, that was usually getting passed along to the tenants in whatever situation it was. But it can't go on forever, and it hasn't. And so I think we had April, May, June with no payments, and then we were back in July making our payments. So, but by that time, a lot of the federal money had gotten into small businesses' hands, which was great. And that's allowed us to carry forward through today. But to answer your questions, the landlords and tenants all handled it differently. I think almost everybody got some sort of relief. It wasn't a long period of time, and it was often dependent on what the landlord's lender allowed.
And now that you're seeing that run out and that the content slate is rather thin at best here in Q1, what are you doing about the bank? Because I find it, let me give you just a little bit more information. I've yet to find anybody, because we sit through these Tuesday calls with everybody, and there's a bunch of us operators, and as Craig Hall would affectionately say, if you find anybody who says they're making money, they're lying to you. Like that Craig Hall imitation there? Give me a thumbs up, Mater. Go ahead.
Very good. Yeah. So the banks, I mean, they want their money. They could not really pressure companies during the heat of the pandemic. It just is bad for business. Everybody was trying to figure out ways to cope with it. But ultimately, they expect their payments, and they expect them on time. I think we're going to start seeing the lenders become a lot less agreeable to be flexible in the next 3 to 6 months. But at the same time, we have a wonderful opportunity on the horizon with this shuttered venue operator grant system that's been set up under the law that was signed, I think, December 27th. And that's a massive amount of money that can go to theaters for a lot of different things. And I think that's going to be extremely helpful. I mean, we personally have got the PPP loan. We also got the EIDL loan from the SBA. And our lender also gave us just like a working capital a loan to help us immediately. But
and now you're gonna get a grant.
Yeah, I think this grant is gonna be really good for our industry.
Yeah, we agree, and I've got some grant questions coming up later as it relates to restructuring. So we'll get back to that as well. Does anybody have any other panelists have anything they wanted to add related to that, or can I keep going for the moment? Okay, sounds like we're good. So let's talk to Kyle and then Rodney for a minute, and then we're gonna come back to you. So Kyle,
hey,
how are you today?
Solid, thirsty. All this talk about alcohol.
Yeah, well, exactly. That's why we're so happy you're here.
That's what's in my coffee cup.
We're going to talk booze, and the folks here at Venue Valet, and particularly Venue Valet happy hours, all like their drink. If we could send Amy a case of Swell right now, she'd be real happy. Yeah. Anyhow, so there's been a lot of changes in liquor laws, right, as it relates to this pandemic. Things to try and help business, right? Takeout. And we should also tell everybody that Kyle is based in Texas, and liquor laws are state related, generally speaking. So let's talk about, a couple different things. First, just touch on permanence versus temporary, right? In terms of takeout and things like that. And second, about serving outside of your premises. So if I wanted to set up a drive-in in my parking lot, does my liquor license, and I'm in Texas, does my liquor license extend to allow me to serve in that person's car and for them to be able to consume that beverage in that car? Or do I need a special permit? So, and then obvious permanence versus temporary as well.
Got it. All right. Well, the answer to both is the classic law school answer of it depends. All right. As far as permanency for all the changes, I've participated in some national conferences over the last year that addressed a lot of this for on-premise consumption, permittees for off-premise consumption, permittees across our nation, and what the various state liquor boards or governing authorities have done to try to help businesses. And as with alcohol regulation, it's more or less kind of the same areas are being targeted. Are a lot of them helpful to our dine-in cinema? Maybe a couple in particular, but of course, for our restaurant friends, alcohol to go has been really big, and opening up delivery, opening up for on-premise consumption permittees that may have been restricted to only serving on their premises, to allowing them to go. Those may have, I think if the industry likes it and you've got lobbyists in place, or you can compel your hometown legislators to help the cause with this, then you may see some permanency with some of these things. In Texas, I know here, the commission and the governor worked together, kind of granted via emergency order the ability for on-premise permittees to sell to go. And there's been a bill filed. Our legislator here in Texas kicked back in just, I think it was last week. There's been a bill filed already to allow that, to make a statutory change to allow that going forward. One of the conditions with that is that prepared food, it was a big requirement for that, which plays in for dine-in cinema. Some of the other things, the temporary measures that have, I think they'll fade away as things hopefully pick back up. Some state legislators were reducing maybe the terms of the permit from 2-year, like here in Texas, to a 1-year, to help out permittees, maybe not have to bite off that permit fee, chunk that they usually do to renew for a 2-year permit. That's going to get yanked depending, the next commission, they feel maybe things are a little more stable because they're not going to change everything to go back to a 1-year permit when everything is 2-year for a permanent basis. Allowing renewals after expiration, carving off an exception for that. That's not going to last, but that may be an avenue for some people. We've had a lot of clients that look up, kind of are finally getting some air and like, oh man, that permit I had expired in November. You have to start over. The commission is granting, typically you've got 30 days after expiration here in Texas, and waiving late fees and the like. Those things I think will fade away as we get back. Some of the things like alcohol to go, hopefully we'll get some traction, but that's going to take typically a state legislator, changing the statutes. And whenever you get involved with legislation, if you've ever had any piece of that, it becomes, particularly with alcohol, it becomes a big horse swap, right? And the industry.
I imagine that there's some significant lobbying that'll happen on both sides, and as soon as there's the first incident that happens in a car, you're going to see the advocacy for MAD and people like that go completely crazy and really ramp up. It's not popular for them to do it right now because there's a huge economic struggle, but that will change once there's a kind of a catalytic incident, so to speak.
I concur. And that's a good segue into kind of compliance concerns that you have maybe, trying to push operations outside. As everybody who sells alcohol, who's selling alcohol, if they're able to do it, given the pandemic, what's all involved with that. Many states, I've talked to my colleagues, and again, a lot of the state governing boards kind of tried to help the industry in the same types of way, are allowing temporary modification of premises. The kind of it depends portion, I would say here in Texas, I would argue if you were like a standalone property, giant parking lot that you exclusive occupancy control over, that technically your permit already extends out there, and you may or may not really need to involve the regulators in setting up shop out there. If they're going to ticket a customer out there for drinking in the parking lot, they're going to ticket you as permittee for a customer drinking in your parking lot. Why can't you sell out there? The reason you don't do it on the regs is it doesn't make sense, right? You can control ingress and egress of alcohol. You can control consumption in your 4 walls. You're not normally doing that out in the parking lot. So when you make that transition, I would say, look to, is any notice required to the regulator, if at all, or does it just make sense even if not, so you don't have them sweeping in while you're in the middle of this event and maybe threatening or interrupting your operations, right? You don't want that. The same compliance concerns that apply inside are going to apply to the outside, right? Don't sell to minors, don't sell to intoxicated individuals. It's going to be that same staff training, same point of sale, same interaction with the customer to help to kind of prevent that. And if you're responsible for controlling, keeping alcohol on the premises, then you're going to do that just like you do inside. You're going to have maybe some signage and some security and staff monitoring to help try to get that. So, but really, same kind of general restrictions. In Texas, there's not a whole lot from a local standpoint that you would need to do involving alcohol, but many other states, you got to kiss the ring of the locals for your alcohol license that they issue and for the state. So you want to make sure with the locals as well that, and again, everybody's kind of trying to work right now and grant this. The city of Austin, where I'm at in particular, I know has tried to let people capture that outside space. Same kind of pitfalls, and compliance concerns as outside, but you should be able to approach some of the same methods for safe and responsible sales inside.
All right, thank you. Moving on, we're going to talk to Rodney Speaks now. Rodney is a pretty interesting story here. As I think John Holstrom might have said, Rodney is the former owner of Moviehouse and Eatery. He sold that to Sinopolis, I think it was late 2018?
19.
But is that right, Rodney? 2018. Yeah. Okay.
About 6-7 months before the COVID hit.
Right. Yeah. In the process, Rodney became the landlord for several of those locations that he ended up selling. And so he brings an insider's perspective to the theater operations piece, right? Having had and built 5 of these prior to selling them. And then he also now has that landlord piece. So he understands the economics and has a tenant that is obviously struggling like the rest of us in terms of exhibition, right? It's no secret that we see their grosses just like they see ours. Well, ours are non-existent, but those that are operating in any case. And we're wondering from you specifically how you dealt with that, what was important to you in negotiations, and did it, knowing those economics, did it soften your stance at all, saying, well, I know what they can and can't afford?
Yeah, so we actually became the landlord the day we sold the business. So we purchased the buildings back simultaneously. And it ended up being 4 of the 6 locations that we had. And so we were fairly new to the landlord business when COVID hit. And I mean, it scared to death. You know, we were scared to death, just like everybody else is. And so, yeah, the empathy that you were asking about was there because 6 months earlier, we were on the other side operating and we knew or know what the expenses are and operating cost and the rent roll is and everything. So from a negotiating standpoint, it actually made it a lot easier for our tenant because we had just lived it, we had owned it. And so we understood the numbers. We didn't have to dive into their financials and really understand what struggles they were having. We knew. And we've always looked at it as a partnership. So, you know, landlord tenant partnership, whether we were the tenant or the landlord. And so, yes, the negotiation didn't last long. There really wasn't much negotiation. They called us and said, you know, we need relief. We're having to close our business. And, you know, what Mark said earlier, it was basically the exact same thing that we went through. You know, we're basically the tenant to the bank is the way I like to explain to other tenants. Is the landlord also is a tenant if you have a bank loan, and we have to make monthly payments just like you're making monthly payments to us. And Mark said that earlier. And so basically what we did is we proposed to the tenant that we would do, which is very similar to what I've heard most other people doing, is we offered a 90-day deferred payment, not abatement, but deferred. And then we would reanalyze after 90 days because nobody knew what was going on with COVID. And so what we did is we did a 90-day deferment for 12 months. So they would start repaying that deferred rent April of 21. So we're approaching that now. And we amortized it over 3 years interest-free. So they would be able to start repaying that rent starting April 21st over a 3-year period interest-free, which we felt was extremely generous. You know, we're not making any money on them and helping them out. And so they opened back up kind of like you guys did, and they stayed open in Texas in their 4 Texas locations that we had. So it was a little bit different than you guys, Matt. And so then when the studios, COVID kept going and the studios had all these releases coming out and then they didn't, they pushed them till 21, you know, obviously the phone started ringing again and we had to renegotiate more rent deferment. And so we ended up giving them another 2 months And at that point, we had to figure out how much more can we afford to give, because our bank didn't work with us. And they didn't give us any 90-day relief or 6-month relief, interest only. So we were still making the payment on our loan, even though we weren't collecting rent from the tenant. And so we were sympathetic with them for another 2 months. But at that point, we're 5 months into deferment, and you've got to weigh out from a landlord standpoint, can these guys actually make up that payment in April?
Right.
And, it's getting to be a pretty big number now added on to your rent. And so that's basically how our negotiations went. I wouldn't say there was a lot of negotiation. It was pretty straightforward. We have a great relationship with our tenant. They have a great relationship with us. And they're a huge company. They're the 3rd largest in the world. And so I would say they were fairly easy to negotiate with, and we were too, because we were the operator.
Right. That brings up a follow-up question, which is how does education work into this? In other words, you didn't need a lot of it because you were an operator. But I can tell you from our perspective, we have spent an extraordinary amount of time over the last year educating landlords on movie exhibition and that kind of thing.
It just made it painless. Literally, we got the phone call and talked to our tenant, and within an hour, we had a proposal put together for them. And obviously, they had to send it to their committee because they're a huge company.
Sure.
And, we didn't hear back from them for a week or 2 or however long, which was extremely fast. But the education it didn't exist because we already were educated. We understood.
That brings up the question of you said you gave them 3 years, 0 interest to go back and pay that. So let's say it gets 5 months deferred and 5 months deferred, and we're not making a whole lot of progress. Let's say it becomes 10 months deferred. At some point in time, with the rent structures that were already in place, combined with the payback of any deferral, this becomes an untenable situation for movie theaters. Does it scare you that you'd have a bunch of buildings back if that was the case?
Well, yeah, because
good. I would think so.
Yeah,
I guess what I'm trying to figure out is
you don't really want them back.
Yeah.
I guess the positive side is if we do get them back, we know how to open them and operate them, but that's only assuming that there's movies to show, right?
Yeah.
So, if there's no movies, we can't do it any better than they can do it or you can do it. So we're all in the same boat. So obviously we want to work with them to try to stay open.
So
there's also a point of balance where the point of no return is, are we better off just to take the buildings back?
Yeah. So
hopefully we never get to that. But we are aware of that.
This is going to launch a whole bunch of additional questions. So I'm going to ask you this, and then Mark, we're going to go to you for the answer, because this is what I wanted to talk about related to management contracts. I suspect that there's going to be a bunch of exhibitors. Don't know. We could use names. We don't need to use names, right? There's some of them that are even large and public that we know are in some significant trouble, right? So there's going to be a lot of theaters out there that are going to be reclaimed by landlords. A lot of them aren't going to want to put the money in that big box to change it into something else. You as a landlord, would you start your own company again, or would you go out and perhaps hire an existing operator under a management contract to operate that theater if you did end up getting one or more of them back?
Talking to me.
No, well, first Rodney, because he's
okay.
got it.
We've actually run that question through our mind many times, and the answer right now is we would get back in the business and operate.
Interesting.
But that's only assuming that there's content, right?
Yeah.
So, we kind of miss not being in the business, if you could say that, right? But given a perfect world where COVID didn't exist, we miss it. But if there's no movies or content, like I said earlier, there really isn't a business, right? Flix is not reopened. We don't want to go reopen to losing a ton of money. So
Yeah, there's some fundamental assumptions you have to make.
We would reopen and operate if the doomsday scenario comes about, and then COVID gets vaccine cures everything, and there's movies being released. So we would do that, yes.
Got it. Okay, Mark, over to you on that one.
Yeah, the same thing. I mean, unless there's something fundamentally wrong with the company or that location, it'll either work or it won't with the industry and whether or not we're getting good content to show. But yeah, obviously we already do that. If I had multiple locations and was renting to other operators, I would definitely step in and run them myself if they couldn't do that, because movie theater buildings are really they're really unique. I mean, it's they're not attractive to a lot of different types of tenants. So there's limited uses that you can make of them. But I think people are getting creative with it, with churches and schools and things like that. But there's a limited amount of tenants that can use those big spaces that are set up like that, especially with sloped floors or stadium seating or whatever.
Yeah. So you now have this additional expertise in running theaters, right? You got one of them by chance, right? Added another one when you figured out how to do that first one.
Right.
And now maybe as a small operator, you have some opportunity to pick up some additional ones that are going to go back to landlords after this all comes down. That's kind of where I was headed. So,
and one of our fears was having a bigger operator show up in our town and build a 20-plex and spend a ton of money on it and pull all our customers away. So we invested heavily in all the things that those operators are offering in hopes that they wouldn't come to our market. So in that sense, I feel like COVID has protected us for a little bit. I don't think people like that are looking to build a bunch of new theaters right now.
Okay. We're gonna switch this back to Jonathan here, because I think that I have some questions about aid and how this factors into restructuring. But then I want to go through. I've got some questions from the audience, and I'm interested in hearing some people's takes on some of these. So we'll go back around here in a couple minutes. Jonathan, one of the things that struck me was when you said, well, if you have no cash, then that's a whole different ballgame, right? If you're out of money. Well, some of us are out of money, right? You're looking at them. But there's also the upside of a significant grant that is headed our way from the federal government. How does that work in terms of timing with restructuring? In other words, if we have, let's just make up some numbers. You've got zero money, and then a week from now you have $10 million. And could you still restructure and utilize that even though you have that money prior to paying it out?
Yeah. As a matter of fact, there's for companies that filed before getting the first round of PPP, I'm not talking about in this industry alone, just generally, and then applied for PPP, or they applied, didn't get the money, filed in the interim, and then wanted the money. A lot of them ran into problems, and bankruptcy courts all over the country were ruling in inconsistent ways. So the latest and the greatest, intelligence on that issue is, while there are arguments to be made, and in some locations, some venues, legal venues that is, you'd be okay. We don't particularly like to pick fights, and so the advice across the board is get your money first and then file. Now, if you get your money first and then file, that's a wonderful thing. Assuming, I'm not advocating filing, but if that's the scenario we're in, that money is not it doesn't comprise collateral of any pre-existing lender. You're under no obligation to just spit it back out to creditors. You can use that money. Around that money, you can build a plan, both a business and accompanying Chapter 11 plan that can pay creditors, hopefully in full over time. The last thing that a responsible operator would do would be to just take the money and start distributing it until it's gone, because at the end of the day, vendors would probably get paid, a couple of, pennies or a nickel on the dollar if that's if that's the tack they took.
Okay. I have two more bankruptcy questions for you. In particular, they're about two companies that we all know. And because this is public information, right? And there's no reason for me to not mention names. We all know that AMC is struggling. They're a public company and they're the largest of the exhibitors out there, and they have no eligibility for an SOS grant. They also don't have personal guarantees on buildings, and landlords could probably take them back pretty quickly in certain cases. What is there to learn from what's happening related to AMC kind of publicly right now?
Well, it's a modern day miracle of the capital markets, right? AMC just raised $400 million.
Oh, yeah, yet again, huh?
Yeah, from stock sales. They raised more since the new year, but 400 million of it came just from new sale of stock. Okay. And that's wonderful for AMC, but not so much for its newest shareholders. Personally, I think, putting your money on 26 Black is just as good of an investment. And to be clear, again, I'm not down on the industry, but the question is, will it recover in time before this newest batch of money gets burned through? Right. And which then drives the question, will the current equity owners of AMC continue to be the equity owners of AMC when the storm is over? And there's a good possibility that the bondholders or banks are going to end up owning the equity. That was my reference earlier to the concept of fulcrum security. Mm-hmm. So, and by the way, if operators can have their locations at 100% capacity by the summer, but the balance sheet still says equity's out of the money. And I think Mark said this earlier, as quiet as your lenders have been, as polite as they've been, put on your seatbelt. They're going to show you a completely different side of themselves. And it's not just because, it was bad for business until now, in the sense that it's like an optics thing. There's not much of a market right now for going concern theaters. There's not much of a market for FF&E. The lenders weren't even staffed up properly in their workout groups to handle all this, but that's what's been happening, during this intermittent period. So, in terms of AMC's relevancy to the vast majority of cinema operators or any creditor of a cinema operator, in a word, it's just not that relevant. It's relevant in terms of how operators and vendors should be planning to survive once they survive the crisis and come out the other end, then, and I think you brought this up, Matt, with Rodney, some operators will have steadied their ships enough to maybe pick up shuttered AMC locations at a bargain price, or otherwise do something with them. So you're right. It can't access SOS. There's no personal guarantees to anybody. It can't squeeze into sub 5. And the professional fee burn rate, i.e. the lawyers and other professionals on a company of that size, and that information is all public if you want to if you were purely curious, the financial strain that adds the ability to really reorganize. I mean, the expenses are hard to fathom if you haven't been through it before.
Yeah, so Sandy Karp phoned in a question here, wrote down a question, and it's for kind of the whole panel here, because it's kind of where I was headed with all this, and I think what may be one of the most interesting outcomes out of all of this, and Rodney spoke to it a little bit, but I think that there's a lot more here. A landlord that has zero cinema experience. We have a couple of landlords that are small landlords that just have this and another project that we happen to sit in, right? They're not some big giant real estate conglomerate with a big operating arm. Does anybody on this panel believe that those type of landlords would want to operate a theater, or is starting a management company right now in the theater business probably a good idea, because there's going to be this need for operators that landlords are going to go seek out to operate these concepts that they take back all over the country? Anybody got any opinion on that?
I think I was probably uniquely crazy to do that. So I don't think a lot of landlords are jumping at the bit to get into the movie business, especially right now. But if they are left with a building that there's nothing else to do with, it's a possibility, especially if it's a small landlord and this is a big part of their investment portfolio.
Right. So Rodney's unique because he says, I can put together a team that can go operate these cinemas. I'm not sure every landlord out there has the ability to do that. And that's why this is an interesting situation.
Well, counterpoint.
Sure.
And, we've seen this, or at least I've seen it because it's what I do for a living. In retail, a lot of retailers now are owned by entities that in turn are now owned jointly by one of the great big landlords and former senior C-suite executives of the company that went under. So if they can recruit the talent, and that's, I've seen it before in other industries, retail, it's happened probably 2 years ago, I would have said half a dozen times or less. Now I could probably say well more than a dozen times that I know of. So, it begs the question in one question, I suppose, is just how specialized is the industry, and how safe, are your execs, there for the picking off, or are they gonna? And that's the other thing. A theme that runs throughout all restructurings, at least of modest-sized businesses, meaning, not the size of not the size of what do you call it, AMC, but it could be 100 million, 200 million of revenue or less.
Right.
If you've got management that is critical, and that management can stay together and not be picked apart, then that management has a lot of power at the table. Now, when you're dealing with an entire industry, I presume that the ability to run a Flix is not that different from running a company that looks and sounds and feels a lot like a Flix.
No, it's not. No, I don't think anybody out there has perfected cinema dining, by the way. So I think that there's lots of different ways to do it, and there's probably a set of best practices that one could adopt to any concept, but that's neither here nor there. I just think there's an opportunity out there. There was a question that came from Paul Marcotte earlier that said, how much cinema consolidation do you see this year? And what percentage of permanent closures do you see this year? I'll answer that first and then let everybody else have a shot at it, which is that I see significant consolidation headed our way, particularly in dine-in. There is no dine-in cinema operator out there right now that has any kind of leverage with the studio partners or with the food and beverage vendors. When I say any, right, that's obviously somewhat hyperbole. Even Flix has some significant leverage and has been able to make some deals that have been pretty good for the business over time. But when you take a 40-unit studio movie grill and a 40-unit Alamo Draft House, and the few of us that are at or around 10, and you combine it together, and all of a sudden you've got 150 dine-in cinemas or 200 dine-in cinemas and 1,000 screens. It speaks to some significant economies of scale that we could get out of this industry. So consolidation of dine-in, I see happening significantly more than I see consolidation of traditional exhibition. My personal opinion, if anybody disagrees, feel free. And then secondarily, as my CEO said on a CNBC interview that some of you may have seen just before New Year's, we're thinking that up to 25% of the screens in the United States could eventually go away here sometime over the next year.
I think that leads in very well to one of the most powerful things that a bankruptcy restructuring can do, and Jonathan can talk about this, is you get to pick out which leases you want going forward. You can reject leases on your worst locations and limit your damages that you have to pay to your landlord to a very there's a formula, but it's a very finite amount. It's definitely not the lease payments that were going to be paid over the remainder of the term. Jonathan can tell you a lot more about that than I can, but.
Well, I don't want to go down that rabbit hole particularly.
Yeah, but it's an option.
Let me just layer on for like 30 seconds or less.
Go ahead, because I have one more for you that I think will be interesting for everybody too. So
okay, so what Mark's talking about is right, of course. There's a cap, a statutory damages cap in the code, which is wonderful. But any liability within the cap is an unsecured claim. It's got to be paid before equity gets to keep anything in a traditional Chapter 11. So subject to the cap, which is a good thing, it still has to be paid or equity doesn't get to keep equity. Now, that comes with several important exceptions, and most notably in a subchapter 5, that creates an exception which you could drive a figurative truck through, which is a wonderful thing.
Keep going, because that was my question. So if you could explain to everybody what a subchapter 5 is in a minute or less, I think it would be really helpful.
I will try.
And the time limits while it's there's some, yeah, go ahead.
All right, so and when we're talking about sub 5, it's really important when we're talking about companies that have where there's personal guarantees. You got to think about the power of a sub 5, not just for the company but for the individual, or at least the credible threat of the sub 5 for the company and the individual. And with respect to the timing, so right now there's a temporary, so in order to fit into sub 5, the person or company wanting to fit in has to have no more than $7.5 million of debt. That amount is because of the laws that were passed, to deal with COVID. It was, and it is slated to return to like 2.7 million on March 27th. But that's not really the right target date to be concerned with. I mean, number one, a lot of people who have a reason to have a knowledgeable opinion believe that that'll be extended past March 27th. But more importantly, there's a couple of very important nuances about that cap. So one nuance is that in order for a debt to count, that debt cannot be contingent and it cannot be, excuse me, yeah, it cannot be contingent and it cannot be liquidated. So in many cases, for example, personal guarantees are still contingent and they are unliquidated. So, you know, an individual might have $50 million of potential claims against them under guarantees, but if the guarantees remain contingent on the day of the filing, that's fine. So that's a wonderful thing from that perspective for the debtor and or its principals. On the flip side, the total debt, that $7.5 million, it's not just the debtor's debt necessarily, but it's the debtor and its affiliates debt put together. That's a hugely important nuance too, in the opposite direction, right? And what that means is if one is going to go down this strategy pathway, one needs to do it not before March 27th. One probably needs to do it much earlier because you got to move before your debt becomes non-contingent. And that is, I'll stop there because that's a legal and analytical rabbit hole that we don't have time for, because it's different depending on the contract and on the state law, et cetera, et cetera. Suffice it to say, the right strategy for both company and guarantor could be to file, but I should say, and if the guarantor files first, the guarantor can file subchapter 5. But if the company files first, then neither the company nor the guarantor will be eligible to file subchapter 5. I'm actually curious to see how many malpractice suits are brought a year from now over screwing up that timing. 30 more seconds on, I told you how you get in or how you don't get in terms of like, why is it a good thing? It is a wonderful, beautiful, elegant tool for a party, whether it's a company or a guarantor who qualifies. Basically, it was created like a year and a half ago. And by the way, subchapter 5, it's a subchapter of what, just to be clear? It's in the name, subchapter of chapter 11. So it's a new type of chapter 11 that, without going down the legal rabbit hole, makes it far easier and less expensive to file and get through a bankruptcy and to confirm a plan of reorganization. I'll shut up now because it's probably a good resting point.
Okay. So I have, I kind of want to end this with predictions, if you will, because I think I'm about out of time unless Amy or Matt tell me to keep going. But I gave everybody what I saw. I didn't hear what you saw. Is this, let me just digress for a moment and I'll give you, we have a landlord in specific, I won't tell you which one, that said that within 5 years, the movie industry is dead. That's a bold prediction, right? To say that it's going to be just in-house, and it's certainly nobody that's on this conference wants to hear, but it's a prediction. I have my own prediction, which is a significant reduction in screens, a new normal related to exhibition and distribution and exclusivity. And I think that there's a potential consolidation of cinema dining to make a really good business out of this that has some leverage, my personal opinion. do you guys have any? What do you see happening? Where are we going to end up as an industry in cinema? And we'll let's start with Rodney, because he's got he's had a pretty good timing related to things in his life, at least as far as I've known him. So let's hear what he thinks.
I think there'll be a consolidation of the general cinemas going away, and you'll have more dine-in theaters coming online, because people are going to go out for the entertainment value where they want to get dinner and see a movie. That's where I think it's going to be going.
Got it. And if you took all the screens in the country and put them together into a big bucket, what percentage of that bucket do you see going away as a result?
Oh, wow. That's
Such a lot of old, really crappy movie theaters, like the original.
I have no idea what that percentage is anymore. So honestly, I don't know. I mean, I would think that the old dumpy ones are for sure gone. I mean, just the cost to renovate them right now and there's typically been a dine-in theater come somewhere within 10 miles of them anyway, if it was a location 20 years ago. So
yeah, so for those of you that know what I'm talking about, the AMC buying Carmike, they bought a bunch of dilapidated old facilities that and then they just stuck an AMC classic banner on it, and those things you've got to figure have to go away as part of this, because there's just no without a significant capital infusion, there's no competing in those particular markets.
Yeah, so Amazon fulfillment center.
Yeah. Okay. Good enough. Mark, Kyle?
I don't have a prediction, but I have a request. Ambiguity in these new SBA guidelines and stuff is helpful, and it allows multiple flexible interpretations. So I would say don't try to get the SBA to tie down specific answers to everything, because that'll just shut all the loopholes. Not that we're trying to trick anybody, but I mean, flexibility is important, and you don't want to give them every hypothetical so they can slam all the doors shut that we could possibly resurrect our industry with.
Got it. Okay. Kyle, I know you deal a lot in the restaurant and liquor world, but what do you know?
Well, as I tell many clients that tell me, ask, what about this business plan? I'm not the consultant type. I've had many concepts come to me and thought, when the client walked away, like, that'll never work, and they're slaying it. And, vice versa, I'll be your first one in line client as a customer, and, they're closed 2 months later. So personally, as a big consumer of dine-in cinema, I'm so ready to get back. My wife and I have 2 kids, and we visited all the area dine-in cinemas around Austin. That was our jam. Now that was our preferred form of entertainment. And we miss getting out of the house and doing that. So I do think that that quality luxury model is still going to be in demand.
It's certainly been well received in the state of Texas, that's for sure. It seems to be the preferred way to go see a movie. So hopefully the rest of the country will adapt, and Rodney's prediction comes true that dine-in will proliferate throughout the country, which would be nice. Jonathan, I'll give you the last word.
Oh, I'm just a lawyer. What do I know about your industry? Other than to say, look, video didn't really kill the radio star, right? I think that the movie industry has survived a lot of stuff, and it seems like incredibly common sense wise that of the broader industry of cinemas versus the dine-in, everyone has been saying about dine-in, it just seems so logically correct. I want to throw one thing out though, unrelated but sort of related. Mark said it. He was talking about a moment ago how the vagueness can be good in terms of the regs, and he was saying maybe we all shouldn't rush out to, right? And then earlier, different piece of the conversation about, well, gee, could landlords seek to own? And the answer or a partial answer to both of those things is, and I don't know the answer. Maybe your industry already does this, but the willingness and ability to act in concert to try to, move in a unified way can be very powerful. Because, if I need an operator because I'm dealing with, this borrower or this tenant, and the other operators anywhere close by refuse to help me, that gives me as the landlord less optionality.
Right. Yep, that's true. Makes sense. All right, Matt, you back to you guys.
I just have one quick question to pose to Mark and Rodney, and you're having your perspective on this during this hour was awesome. And thanks for sharing. I've known Rodney for a good number of years, and I feel like I'm really glad you came on and shared the story and your perspective on this. But I'm wondering if you could maybe bend just a little bit and try to put yourself into a normal theater or a normal landlord mindset, right? Meaning you aren't an operator, you didn't own 5 cinemas a couple of years back, and all the, I don't know if you were on earlier when we spent a couple sessions talking about what else you can do with this square footage, right? And I think Mark mentioned, these buildings are pretty unique, right? It's like you can't just go turn this thing into a daycare tomorrow or an Amazon distribution center tomorrow. It's like that has cost. It's just the way they're constructed. They don't snap over to something else really quickly. And yet we had a good number of sessions where some creative TK architects and fresh strategies were talking about some relatively, I want to look at it as simple. They're not, right? But relatively straightforward things you could look at doing to adapt the building. And you look at, Rodney, I've been in all your buildings, right? Some of that discussion or some of the stuff they presented, I right away always think of trails because I live 2 minutes from it. But, to take down one wall in the lobby and then a sports bar is built and you instantly turn something into what our neighborhood needs, right? As a landlord, you look at that opportunity, you're the landlord at that building. Do you think other landlords are thinking that way, where it's like, hey, I know my tenant is suffering, but I'm a pretty creative guy, and I think I'm not bailing on cinema, but I want to be a part of what's going to happen next with this square footage because it's my building. And so rather than in someone, I think you'd mentioned, Rodney, you look at it as a partnership, right? But my business is a partnership too, right? With my customers. And I'm trying to make sure my business succeeds. And the only way it can succeed right now, because most of our revenue comes from theaters, is I continue with John and Amy and others to do stuff like this, to keep things moving forward, right? So do you think most landlords, do you think most landlords think about it that way, or are they starting to panic?
I think they're talking to Jonathan about their bankruptcy options once the theaters file, to be honest with you. They're scared to death. They're for sure not thinking about a creative bar situation. They're trying to figure out what happens when the theater files Chapter 11 or Chapter 7, and what grounds do they have to take, the next step.
Yeah. Mark, same thing?
I mean, I think the ultimate answer is something has to be done with the building to make it work. Even if it's a liquidation or whatever, somebody's going to get it. And so the smart landlord will be very creative and be thinking about those sorts of things. And one option that you could do as a landlord, especially if you're allowing flexibility in the use restriction that might be in your lease, would be to accept some sort of percentage rent in the event that whatever you're turning it into or adding onto is successful. The landlord could share in some of that profit instead of getting its fixed rent. Kind of makes it more of a partnership. But I do think landlords are going to have to be nimble and flexible and smart and be thinking about these things themselves, because somebody's going to have to think about it. I mean, you'd be better off to think about it than letting the Chapter 7 bankruptcy, trustee have to think about it. So,
right. I mean, we had one customer that we just did a job in Aruba, just opened up a huge, their third theater and a third building in Aruba. And they have a PF Chang's and a Starbucks in the lobby.
And two
other restaurants that
Yeah.
one hadn't been named yet, I think an Italian joint. Right?
Maggiamo's.
But they were literally in the lobby, and on certain nights, they each took turns serving food in the theater. They partnered and they bought some of the franchise, right? They put partnerships together to, I guess, diversify, so to speak, right? And I think they're the landlord too, of that project, right? So, and they just opened like literally 60 days ago, right? So right in the middle of craziness, they are taking that direction, and that's different. You don't see that here. You don't see a Chick-fil-A in the lobby of a movie theater, or a Starbucks typically in the lobby of a movie theater. But right now, Chick-fil-A is pretty darn busy.
We're actually going to see that tour.
Chick-fil-A's, we're going to see that tour.
Yeah, well, I was going to say, if people would have attended the Tuesday happy hour, they would have already seen that tour. And they would also, and I will not elaborate on this publicly, they would also know what all these references in the chat is to the wombat.
Yeah. we know that's one of your favorites.
I can hear Amy all the way from here.
All right. Well, I appreciate you doing this, Matthew, Rodney, Mark, everybody. Thanks for coming. Good use of time. It wasn't exactly the pick-me-up hour of the slots we've had so far, but attorneys never are, right? No offense. Yeah, I mean, that's not what people expected. Thank you all.